Hey, welcome back to Legal Clarity. I'm your host. Today we're diving deep into one of the most important asset protection concepts that wealthy real estate investors and experienced attorneys use every single day. Why owning property in your personal name is one of the riskiest financial decisions you can make, and exactly what to do instead. Let's get into it. Every piece of real estate you own in your personal name is a direct target. A target for lawsuits, a target for creditors, a target for judgments, and a guaranteed entry point into the probate system when you die. Wealthy real estate investors almost never own property in their personal name. They use a simple legal structure that most regular property owners have never heard of. And today I'm going to show you exactly what it is and how it works. Let's start with the risk. When you own property in your personal name, any lawsuit related to that property is a lawsuit against you personally. A tenant slips on ice outside your rental, they sue you personally. A visitor is injured on your property, they sue you personally. A contractor dispute escalates to court, your personal bank account, your other properties, your savings, and your retirement accounts are all potentially at risk. Even your primary home can be at risk, depending on your state's homestead exemption limits. And when you die, every property in your personal name goes through probate, a public, slow, expensive court process that can take months or years and cost your family thousands of dollars in legal fees. The solution that experienced investors use is the LLC, a limited liability company. An LLC is a separate legal entity. It owns the property, you own the LLC. This creates a critical legal wall between the property and your personal assets. If a tenant sues the LLC, they can only pursue the assets owned by that LLC. Your personal savings, your other properties, your retirement accounts, protected. If the LLC loses a judgment, only the assets inside that LLC are at risk. And when you die, the LLC continues to exist and can be transferred to your heirs without probate, saving your family months of court time and thousands in fees. Here is how to set it up correctly. Step 1. Form a separate LLC for each property. Do not put multiple properties in one LLC. If someone sues over one property and wins, all properties in that LLC are at risk. One property, one LLC. Step 2. Open a separate bank account for each LLC. All rental income goes into the LLC account. All expenses are paid from the LLC account. Never mix personal and LLC finances. Step 3. Transfer the deed to the LLC. This requires a deed transfer in your county, usually a simple process that a real estate attorney can handle for a few $100s. Step 4. Update your insurance. Make sure your property insurance names the LLC as the insured party, not you personally. Step 5. Check your mortgage. Some mortgages have a due on sale clause that can be triggered by a property transfer. Talk to your lender or attorney before transferring. Here is the bottom line. Every property you own in your personal name is an unprotected liability. The LLC structure costs a few $100s to set up per property and protects an asset worth hundreds of thousands. The question is not whether you can afford to set up an LLC for each property. The question is whether you can afford not to. One lawsuit, one judgment, one bad tenant, and everything you own personally is at risk. Talk to a real estate or asset protection attorney this week. And that's it. 5 steps to move every property out of your personal name and into an LLC. One property, one LLC, one bank account, updated insurance, and a quick mortgage check. If you own any rental property right now in your personal name, this is your most important next step. Share this with any property owner you know. Subscribe so you don't miss next week, where we cover how to move your money legally before a lawsuit finds you. I'll see you in the next one. Take care.